A warm welcome to all of you. My name is Jeff Handmaker, and I am an Associate Professor of Legal Sociology at the International Institute of Social Studies, the ISS, of Erasmus University, Rotterdam. I am also an adjunct faculty member at the School of Law, University of the Witwatersrand in South Africa. This is the fourth and final webinar in the series Untold Stories about Occupied Palestine, entitled The International Court of Justice, South Africa versus Israel. These webinars have aimed to elevate current discussions around the application of international law and its social and political dimensions to the long-standing impasse between Israel and the Palestinians, making clear the violence that has erupted since October 2023 both has an important context as well as profound implications for the international legal order. This four-part webinar series has been hosted by the ISS with colleagues from the Legal Mobilization Platform in conversation with academic and societal partners, and has been co-organized with Francesca Albanese, United Nations Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967, and her professional staff, and in particular, Sarah Troyan. Alongside her role as Special Rapporteur, Albanese is an Italian lawyer and scholar who has written extensively on a range of international law topics, including atrocity crimes and genocide. In the previous webinars of this series, speakers have touched upon numerous aspects of Israel's occupation of the Palestinian territories in Gaza, the West Bank, and East Jerusalem. Many of us have been following closely the cases coming before the ICJ, the International Court of Justice. The first was a request for an advisory opinion by the United Nations on the legal consequences arising from the policies and practices of Israel and the occupied Palestinian territory, including East Jerusalem. This case has involved an historic participation of a large number of countries and international organizations. The court's decision is still pending. So today we will discuss another case in the ICJ, namely a complaint by the Republic of South Africa lodged on the 29th of December 2023 that was accompanied by a lengthy written submission by a team of international lawyers, including one of those guests in the screen, regarding alleged violations by Israel of its obligations under the Genocide Convention in relation to Palestinians in the Gaza Strip. Following oral arguments by the legal teams of South Africa and Israel and a series of 3 judgments in January, March, and May 2024, the International Court of Justice has demanded that Israel immediately cease its military operations in Rafah and to allow for very urgent humanitarian assistance throughout the Gaza Strip. The court has called for Israel to allow for fact-finding missions, internationally mandated bodies and/or officials, investigators, and journalists in order to assess and record conditions on the ground in Gaza and to enable the effective preservation and retention of evidence. Israel has so far ignored these and several other demands. At least 4 other member states have joined South Africa in support of its claim, most recently Spain, which filed a declaration of intervention just a few days ago on the 28th of June 2024, in which it emphasized various state obligations under the Genocide Convention, including the obligation to punish states violating the convention. The reports of Francesca Albanese have made extensive reference to the subject matter falling under the terms of South Africa's complaint, in particular her 25 of March 2024 report, Anatomy of a Genocide. She confirmed in this report that the ICJ had warned that, quote, acts committed in this latest onslaught may amount to genocide. The court found a plausible risk of irreparable prejudice to the rights of Palestinians in Gaza, a protected group under the Genocide Convention, end quote. Albanese has also underscored that the court has, quote, ordered Israel to take all measures within its power to prevent genocidal acts, prevent and punish incitement to genocide, and to ensure urgent humanitarian aid, end quote. To better understand these issues, their root causes, and the role of the ICJ in relation to the case brought by the Republic of South Africa against Israel, we will interact with Albanese and 2 other noted experts. We are very privileged to welcome Christopher Gevers and Giulia Pinzauti. A warm welcome to you both, and a few words of introduction about our guests. Dr. Christopher Gevers is from South Africa, a lecturer in the School of Law at the University of KwaZulu-Natal. Christopher teaches human rights and international criminal law at the University of KwaZulu-Natal. As a critical legal scholar, his research is focused on international law, and in particular, international criminal law and international humanitarian law, as well as international legal theory. He is currently editor-in-chief of the South African Journal on Human Rights and has previously worked for Amnesty International and the International Crisis Group, amongst other places. Welcome, Chris. Dr. Giulia Pinzauti is Assistant Professor of Public International Law with the Grotius Center for International Legal Studies at Leiden University's Law School. She has served as a legal officer for the ICJ, the Office of the Prosecutor for the International Criminal Tribunal for former Yugoslavia, and for other international criminal tribunals. She previously worked at the University of Florence and is currently on the editorial team of the Leiden Journal of International Law and for the Journal of International Criminal Justice. Thank you also, Giulia, for joining us. To our listeners, after we have heard from our well-qualified experts, including, of course, Francesca Albanese, there will be a discussion. You may pose questions at any time, addressed to either or both or all three of the experts using the chat function in Q&A. You'll see that box on the bottom of your screen. So first, I would like to get to the essence of this claim, and I'm going to just shoot off a question directly to Giulia Pinzauti. Giulia, what is the essence of South Africa's case against Israel? What is South Africa actually requesting from the court?
Thanks, Jeff, for having me in the first place. Well, South Africa's case at its core is that Israel has breached the Genocide Convention in three ways: by committing genocide against the Palestinians in Gaza, by failing to prevent it, and by failing to hold senior Israeli officials and others accountable for their incitement to commit genocide. Before the court, South Africa argued that through its assault on Gaza, Israel is killing Palestinians in the thousands. It's causing them serious bodily and mental harm through injury and forced displacement, and is imposing measures that are intended to prevent Palestinian births and inflicting conditions of life that are calculated to bring about the destruction of the Palestinian as a group in the long term. This has to do with the imposition of a total siege on Gaza, including the cutting of water, electricity, fuel, and restrictions to the delivery of humanitarian aid that we've all seen. And South Africa argued that Israel is carrying out all the acts that I mentioned with the intent to destroy the Palestinian people of Gaza as a group that is protected under the Genocide Convention. And in a genocide case, this is the part that is really difficult to prove, the specific intent that is required for the crime of genocide. To prove Israel's specific intent to destroy the Palestinian group, South Africa referred to repeated statements by Israeli state authorities, including its highest officials, the president, prime minister, and minister of defense, amongst others. And in addition, according to South Africa, genocidal intent in this case can be inferred from the way in which Israel is conducting its military operations in Gaza, including the failure to provide or ensure the provision of food, water, medicines, fuel, shelter, and other humanitarian assistance to Gaza's besieged population. Can also be inferred from the fact that Israel is continuously pounding this tiny strip of land that is one of the most densely populated areas in the world, where people are trapped with no possibility of getting out and are evacuated to even smaller areas where they continue to be attacked. And I'll stop here in the interests of time, but my summary in no way, I think, does justice to South Africa's case. What is South Africa requesting from the court? It's requesting a declaratory judgment that Israel has breached its obligations under the Genocide Convention, must cease those breaches, and must offer guarantees of non-repetition of those violations. But Israel must also ensure that the persons that have committed genocide or conspired to commit genocide or directly and publicly incited the commission of genocide are punished. And Israel, to that end, must collect and conserve evidence related to the commission of genocidal acts against Palestinians in Gaza. Last but not least, South Africa asks the court to declare that Israel must provide reparation to Palestinian victims, including by allowing the right of return to those displaced, by respecting their human rights to the fullest without discrimination, and by providing for the reconstruction of what it has destroyed in Gaza.
Thank you very much, Giulia. That the last one, I think, is extremely pertinent. It's hard to imagine, of course, but it is extremely important that we be reminded of that. To Chris, in previous seminars you have organized on this topic, you've implied that this case is really quite important, not least given South Africa's own history of atrocity crimes and corresponding multiple appearances before the International Court of Justice over the past several decades on issues not least around apartheid and its occupation of what was then called Southwest Africa, now called Namibia. Can you elaborate for us, Chris, why this particular case has such historical importance from the South African perspective?
Thanks, Jeff, and thanks. It's great to be with you and my fellow panelists and all the listeners. So I think one can think about the historical significance of this case in at least three different registers. So the first, as you mentioned, is that the last time South Africa was involved in the contentious proceedings before the ICJ, it was on the wrong side of that case, right? So South Africa, apartheid South Africa as it then was brought before the court in the 1960s by Liberia and Ethiopia, who challenged South Africa's implementation of apartheid in Southwest Africa formally, but also by implication challenged the legality of apartheid implemented in South Africa as well. This was very much the strategy of those states. So in the sense, South Africa comes before the court as a way of trying to right that wrong, to place itself on the right side of history generally, but in particular on the right side of an ICJ case, given how that case unfolded. So that's the first thing. For South Africa, it's very significant to place ourselves on the right side of history. Secondly, I think is to draw attention to the interesting parallels between that case from the 1960s and the present, right? So Liberia and Ethiopia brought South Africa before the ICJ in the 1960s on behalf of all African states on the basis that there was a common interest in opposing apartheid. South Africa brings Israel before the court today on the same basis, on an erga omnes obligation, which if we want to read our history closely, we can credit back to African states' understanding of violations of international law as being in the interest of all states to enforce and to oppose. The second is in the substance of our claims. So we have in the application and in the way that the claim is framed, drawn attention to the continuities between colonialism and apartheid and the present genocide. In the same way that we have that opposition to apartheid from the Third World made those continuities clear, including in things like the Apartheid Convention and the opposition to the occupation of Southwest Africa. There are also parallels that are interesting in Israel's response, which mirrors in many senses the apartheid government's response to the case in the 1960s, right? So the apartheid government's response was technical, taking technical points like, is there a unispute to a dispute? The apartheid government's response also denied the reality on the ground that was very clear for everyone to see, that Southwest Africans were being oppressed. And the apartheid government's response in the 1960s was to call into question the bona fides of Liberia and Ethiopia, to say this was an abusive process. And we've seen shades of all those arguments in the present. So the historical parallels run into the substance. And then thirdly, I think it's important to note the significance of this case for the court. So in the 1960s, it was significant for the court in the aftermath of decolonization. African states put a lot of faith in the court to come to their assistance in respect of Southwest Africa because the General Assembly and the Security Council have failed. Today, we see a lot of faith as well being placed in this court to step up at a moment in history where the states of the Global South are not sure the international system can bear the weight of its responsibility. And in some senses, 1966 is a lesson for this court as well. 1966, the failure to come out against apartheid almost led to the collapse of the court. African states threatened to withdraw from the court. There was a strong pushback against the court. It took many years for African states to come back before the court and to reinvest in international law. And one might say that the court is in a similar position today, that the failure to come out on the right side of this case might have similar consequences for the court at a particular moment in the history of the international order, when African states and third world states generally are calling into question the legality and the fairness of that order.
Thank you very much, Chris. That historical positioning is really quite crucial, and it also gets to the functioning of the court. What it is that the court is asked to do is, in a very broad sense, speaking to the work of the United Nations much more generally, and its very long history in seeking to resolve conflict. So thank you very much for that. Francesca, as I already mentioned, you've devoted an entire report to this topic, carefully breaking down the elements of the crime of genocide, which again, to our audience, is really important to read. But my more specific question here is how the court has responded to South Africa's request thus far.
Well, it seems to me that there has been a response to South Africa's request thus far, in the sense that the court has treated South Africa's demands with urgency. South Africa lodged this case, submits this submission on December 29, and by the 26th of January, the court issued its first set of preliminary measures, ordering, and I will not repeat myself in the interest of time because Giulia has already gone through it, but so it had those preliminary measures been complied with, we wouldn't have seen the further carnage that in fact has taken place as of January 26th. What has been striking, particularly the day after the adoption of those preliminary measures by the court, is that in fact Israel has tried to distract international attention from the case by mounting a scandal, unsubstantiated scandal against UNRWA, saying that UNRWA had personnel, at least 12 staff members involved in the 7th of October attacks, etc. And after this, 18 member states have suspended funds to UNRWA. So it seems to me that there is a response. So there is a response from the court. There is a lack of compliance from Israel, followed by lack of compliance of other states. Because one of the, as Giulia mentioned, one of the recommendations was to ensure unfettered humanitarian aid, which in fact not only has not happened, but has been expressly violated the moment UNRWA has been weakened, because UNRWA represented one clear lifeline for the Palestinians in terms of entry and distribution of aid. Not only Israel has not complied with the preliminary measures, but has fully violated them, especially, and I want to stress the humanitarian aid, which is not an act of charity. Israel, as the occupying power, is obligated to deliver, to ensure access to humanitarian relief to the population under occupation, which means access to food, access to shelter, access to safe zone, which has not happened. On the contrary, Israel has further restricted access of humanitarian aid, has used excessive force toward both convoys and people gathering to receive humanitarian aid, and starvation has continued and continues to grow. There has been another set of measures ordered at the end of March, insisting particularly on the need to ensure humanitarian aid. Now, I want to say as a last point that I think that probably South Africa did take into account some of my findings and my arguments, particularly, and again, this is another point than Giulia somewhat referred to, because in the genocide report, I not only I indicated genocidal acts and the mens rea behind them, but I also specified that one of the critical elements, which goes to the core and makes goes to the core of the Israeli legal defense team argument before the ICJ, but also makes its defense collapse, is the fact that Israel has justified its acts as in compliance with international humanitarian law. And in fact, this has been a humanitarian camouflage. Israel has justified the ostentatious violations of international humanitarian law. Now, the last set of measures ordered by the International Court of Justice, in my view, are the most comprehensive, which, if read attentively, would lead to an end of the hostilities. But again, we are facing a complete failure of the international and the multilateral system, because even in the face of an UN Security Council resolution asking for a ceasefire, no one really complies with it. Surely not Israel, but not the United States or other European Union member states. Concerning, if you allow me one more minute, Jeff, it's interesting what Chris was sharing in terms of historical background, and it's an incredibly important point that it was the liberated, the decolonized world which acted within the UN to help liberate South Africa and current Namibia from the yoke of apartheid. I feel that South Africa has been, at least initially, very much alone. And now, yes, there are other countries, but I do fear, and this is up for discussion, that at the level of Africa, there is less unity than in the 60s in acting against apartheid and settler colonial apartheid practices, of which what we see today is an escalation and acceleration.
Thank you very much. And I think that a couple of the very poignant points that you made just now, one is that the court had ordered humanitarian assistance. And then Israel's immediate response was not only to ignore that order, but even to begin on the shaming campaign, the slanderous campaign against UNRWA, the very most important, arguably humanitarian organization in the area. Thank you very much. We're beginning to get some very interesting questions coming in. Please keep them coming. And after a few more minutes here of discussion, we will begin to answer them. I now would like to get onto the implications of the court case. The World Health Organization, UNICEF, the World Food Programme, in other words, some of the other humanitarian organizations that Francesca was referring to, as well as non-governmental organizations, experts, UN, and other UN officials, in addition to Francesca Albanese, including the Secretary General himself, have repeatedly warned of a humanitarian catastrophe due to Israel's continued war in Gaza and limitations on the access to humanitarian aid. So this really continues where we left off, Francesca. Have we reached this catastrophe now in your assessment? And does this add further weight to South Africa's case against Israel, or will the court just continue to be repeating the same recommendations it's already made? And now I'm getting somewhat to the questions that are being posed.
Frankly, I think that it has. I mean, I'm not the only one in the UN system which has used the word catastrophe over and over since the month of October. But a genocide is beyond catastrophe, and Israel has committed genocide. I keep on exchanging. I'm flabbergasted by the lack of action vis-a-vis this, because I think that there is not only here the shock to see Israel escalating its violence beyond the point of non-return. And again, it's much worse than a catastrophe here. A catastrophe doesn't give the sense of the intent to cause it. This is why it's important to talk of what it is. It's a catastrophe, within a genocide. I do feel that it will be very, very difficult for the years and maybe for the decades to come to deal with the consequences of what Israel has done, both within the Palestinian society and within the Israeli society. Because and again, it's today in the era of open technology and access to open sources, information, we can see that various segments of the Israeli society keep on relaunching these genocidal calls against the Palestinians. So, what is the UN? What is the UN doing in the face of this? I think the UN is as fragmented as ever. Probably this is the most critical point and the lowest point in terms of compliance with international law or lack of compliance with international law, in terms of failure of the political system to respond to a crisis over and over, but also from a humanitarian point of view. There are all the resources to help the Palestinians not to starve. This is what we are talking about, not to die because of lack of antibiotics, because of lack of, of painkillers. And still, Gaza has been brought back to the Middle Age. And the fact that the UN cannot stop all these speaks to the effectiveness of the UN and also the capacity to avoid and address and stop a country which is advancing a genocidal campaign without any excuse, but rather as a raison d'être, because today it's undeniable that we have reached the highest point of Israel's war against the Palestinians, because the Palestinians are the not wanted, the unwanted one, because of their indigeneity in the land.
Thank you very much. Giulia, the court, as we've already heard several times, has issued 3 preliminary judgments following oral argumentation and written submissions. And of course, now we have Spain involved. Each of these judgments that the ICJ has issued have been accompanied by provisional measures. But in light of Israel's persistent refusal to abide by the court's orders, is the court likely to issue stronger measures to try and compel compliance? And this relates indeed to a question that one of our participants has posed as well.
Yeah, I think it's undeniable, as Francesca was saying, but also regrettable that Israel failed to comply with the provisional measures orders issued by the ICJ. Let me underscore that the court's orders are binding on Israel, and failure to comply constitutes an internationally wrongful act, a violation of international law, for which Israel bears responsibility under international law. Is the court likely to take stronger measures going forward? Possibly, yes. I think we already saw the court going in this trajectory. Over the past few months, it has indicated in its order measures that are progressively more detailed and more incisive, I would say, culminating with the order for Israel to suspend its military operations in Rafah Governorate, which was arguably already implicit in the orders issued in January and subsequently, but now is explicit in the order issued in May. But the problem is that compliance with the court's orders is left with the parties, and there is not much that the court or South Africa, for that matter, can do to enforce compliance with the court's provisional measures. No doubt, the court will ascertain Israel's non-compliance with the provisional measures ordered, but this will only happen in the final judgment in the merits. So it could be a few years from now. And we cannot wait until then. We need to act now. But those that have the capacity to influence Israel's actions, in my view, are third states and international organizations. So these are the actors that have the capacity to induce compliance. Why do I say so? Because all state parties to the Genocide Convention have the obligation to prevent genocide. And the court itself has said that this obligation arises, quote, at the instant that a state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. We're clearly at that stage now. Actually, we passed that stage long ago at this point. So all state parties to the Genocide Convention, which means all state parties of the international community, have to take measures within their power to prevent the commission of genocidal acts. But still, there are many states that are supporting Israel diplomatically, financially, and militarily, providing it with weapons, despite the ICJ provisional measures orders, despite Israel's blatant violations of international law in the conflict in Gaza. So why are these states continuing to support Israel? I would argue that a complete arms embargo is called for, not just under the Genocide Convention in light of the court's ruling so far, but also under Common Article 1 to the Geneva Conventions. Under this provision, state parties to the Geneva Conventions must do everything reasonably within their power to prevent violations of international humanitarian law. And all that is required to trigger this obligation is an awareness of the risk that, for example, arms transfer may assist in a violation of international humanitarian law. The awareness is but heightened after the ICJ ruling, and this ruling clearly put states on notice that any further armed transfers will violate Common Article 1. So these continued provision of military assistance, in my view, undercuts the authority of the court and its ability to strengthen international law.
Thank you, Giulia. So this makes me think of the case currently pending, actually in the Supreme Court now in the Netherlands, the F-35 parts. There's been a similar case brought in Denmark, and I think another one in Germany, if I'm not mistaken. I'm also thinking of Spain's intervention, which is emphasizing punishment alongside, of course, other elements of the Genocide Convention. And maybe just another brief additional question. Is the court suggesting basically that there are obligations not only for Israel, but actually all states? Is the court suggesting this in its implying this in its orders?
I would say it's not, well, in some of the separate opinions, for example, not so much in this case, but in the case that was brought against Germany by Nicaragua, there was a reference to this in the separate opinion, for example, of Judge Sarah Cleveland, the US judge. But I think one of the ways in which this case is so important is that when we will get to the point of having judgment on the merits, the court will hopefully clarify what the obligation to prevent entails, because so far there's not much clarity on that, although I would argue it's one of the most important obligations in the Genocide Convention. And we're still debating what it means and what is it the state must do. But it's clear that it's an obligation.
Thank you very much. Okay, again, we're getting some really interesting questions. We'll get there in a second. I just have one more question, preliminary question for Chris, who's rejoined us, who's had some connectivity problems. This, of course, is unavoidable. Chris, can you hear us okay?
Yeah, I got you. Thanks, and apologies.
Not at all. Chris, we have, of course, a colleague well known to us, renowned international legal scholar, Dr. and Professor Noura Erakat. She's comprehensively argued how the functioning of international legal institutions in relation to Palestinian claims reveal that the system only dispenses, quote, justice for some. Was this trend also evident in relation to the ICJ's handling of South Africa's claim? Or has the Apex Court been behaving in a more consistent and even-handed manner?
So I think, that's really the question, is what does international law provide justice for some? And I think it's important to recognize the responsibility that's placed on the court to answer that question in the negative. It really is the last bulwark against that conclusion being inevitable. So it is standing following the failure of the Security Council, following the failure in many senses of other international organs, following the really drastic differences between the responses, for example, to Ukraine and to Gaza, that the court really has to answer this question for all of us, whether international law can truly provide justice in an even-handed way. And it's a tremendous responsibility, and I don't envy the court. I agree with Francesca that the court has answered this question, or has acted swiftly and firmly so far, and that's very much encouraging. I think one way to think about this is by comparison. It certainly has acted in a swifter and firmer manner than the International Criminal Court. We might think of its sister body. So the signs are very encouraging in terms of if we put those two reactions side by side. But I think we have to remember what Judge Clady said in the last decision, which is the court is only a court. The way international law is meant to be enforced is by states doing their bit once the court gives an order, and by states intervening both concretely in the court, as some have, but far fewer have, for example, than intervene in Ukraine. A number of states have said that intervene and haven't formally intervened. The interventions we have are welcome, and I encourage people to read them, in particular Colombia's and others. So states should be intervening because of the nature of this case. States also should be enforcing the orders of the court. They don't need to be invited to do so. Once the court makes a determination, states should invoke the responsibility of Israel and should use whatever weapons and means they have at their choice to enforce the orders of the court. So I think it's both an important test for the court, and I think we should encourage the court to continue to pursue it in the way that it has, but we also shouldn't put all our faith in the court. We should recognize that this is ultimately an international order that's enforced also by states, and states should do what the court has opened up the window for them to do.
Jeff, before you get into the debate, may I chime in with a...
Yes, please.
I think that there is another historical element of this case which is striking and doesn't seem to me that many in the scholarship, but surely member states are, other than those from the global south, are eager to see, and it's the fact that this is the first settler colonial genocide brought before a court. And I think that the South Africa legal team has done a splendid job since the very beginning in making a case for Palestine as a protracted case of injustice, where this genocide is the ultimate criminal act of a series. At the same time, what I'm really scared of is what constitute existing jurisprudence, which the court might rely upon, which is, excuse me, but it's not necessarily fit for purpose, because the court has never dealt with a case of settler colonial genocide. So, there has not been the Native Americans litigating it there, or someone litigating for the Native Americans in the US against the US, or against Canada, or the Aboriginal against Australia, or the Maori, there's been not a genocide, or the Herero versus Germany. So this is the first case, and it's of an historical importance. So I do hope that there will be enough attention to these in the coming submissions to the court.
Thank you very much, Francesca. And again, we're talking about consistency, even-handedness. Chris, we're going to go back to 1966 in a moment, because there's a very interesting question posed in that regard. But Francesca, maybe to also continue with you for the moment. There's a question from Aisha. She says, thank you very much for speaking to us all. There's a question for all panelists, but I'm going to pose it to you. I was wondering if anyone would like to comment on the political consequences of the UN Security Council on the legitimacy of the International Court. Somehow, it seems on the outside to us as non-experts that the composition of the Security Council ensures a justice system that essentially does not work. Is the International Court truly independent? What is your insight?
Well, without prejudice to the independence of the court, I think that there is no entirely independent body. And the reason why, and this, I mean, I'm speaking as a human being who's been a lawyer for a long time now, and not just the UN Special Rapporteur, but I think eventually organizations are made of human beings. And we have seen, now we know what the former prosecutor, Fatou Bensouda, has been exposed to, what she has been subjected to in terms of slander, in terms of threats, and we appreciate their work and their contribution even more today. So yes, in that case, the independence of the office of the prosecutor was upheld despite the delay of the court. We saw that the investigation, eventually the ground for the investigation was ready. I do see that the current prosecutor has not prioritized the case of Palestine. This is a say. Does it speak to the independence of the court as a whole? I do not know, but certainly it has undermined the functions of the court in the eyes of the entire world, and it has cemented that sense that, as our colleagues and Noura rightly says, is just justice for some, which we, of course, we stand against. So, yeah, I mean, the effectiveness of the court is really at stake here.
Thank you very much, Francesca, and also for referring indeed to the work of the sister court, the International Criminal Court, which is following this closely as well. So, Chris, again, I said I was going to be coming back to your historical contextualizing. Another one of our panelists here, our attendees, has asked, could you share what the court failed to do in 1966? Did it rule in favor of apartheid South Africa?
So that's a great question, and we have to take it in two parts. So what happened in 1966 was that the court had already had given a favorable decision in 1962 by a very thin margin, saying that it had jurisdiction. And then in part because of the death and illness of some judges and the replacement of some judges, but also because of some shenanigans between the Australian and the British judges, which managed to convince the Pakistani judge to recuse himself. It meant that the bench was altered in 1966, and essentially the court reversed its previous decision. And it was a very scandalous moment for international law, not just because of the substance, because of the irregular procedure. The court essentially turned around and said, actually, we don't have jurisdiction. Liberia and Ethiopia don't have any interest in this case. And in some senses, we don't have to worry about that because that was a very different court, in part because of what happened subsequently. So after that decision, African states and states of the Global South insisted on the court being more representative, and we do have a much better representative court today because of those efforts to make sure that it wasn't the old guard that controlled the court. And certainly one expects that we won't have that level of outright interference in this case. At the same time, I think sometimes the scandal of that moment, where the court essentially reversed its own decision, overshadows the fact that the case wasn't going that well in the 1966. So African states and Liberia and Ethiopia were up against a formidable South African legal team, were up against an international law that, as Francesca has said, has never really dealt with settler colonialism. And that in many senses, the case is not certain that South Africa would have lost it had it even gone to the merits. And so we have to be aware of both how we've changed since 1966, the court's composition, but also how we need to look for precedents in international law, for traditions of international law, for examples of international law, for state practice in international law from the Global South that will prevent us or rescue us from once again putting faith in international law that has never really addressed settler colonialism. So we need to think critically about what are the traditions, what are the histories, who are the scholars, who are the states that have practiced, that have opposed apartheid, that have opposed colonialism, that have opposed genocide consistently, and how do we weave together those precedents into a different international law? Because we may be in a very different place in terms of the structure of the court, but we have to make sure that we also move and invoke a different international law from the international of the 1960s. And for those who study international law, we know that this is not always the case, that we have to be bold, we have to think creatively, and we have to be very careful that we don't once again place all our faith in an international law, which was not meant to oppose settler colonialism. In a sense, South Africa can redeem international law if it can invoke the traditions and the alternative visions of international order that have been pregnant in the Global South's practice for the last 60 years, but place these front and center. And I think you can see that already in some of the submissions, that South Africa has invoked precisely those understandings of genocide, of colonialism, of apartheid, that really have been the mainstay of international from the global south. And that needs to be at the center of this case going forward.
Thank you very much, Chris. And I'm reminded also by a comment that Professor Richard Falk, another legal scholar, made in relation to this 1966 decision, which indeed did find in favor of South Africa's position. This decision so outraged the international community, particularly those in the global anti-apartheid movement, that it really galvanized the global anti-apartheid movement in a way that it hadn't seen before. So that's also worth mentioning. So, Giulia, there's a question from another colleague of ours, Otto Spijkers. He asks, what do you think of the applications for permission to intervene submitted by Nicaragua, Colombia, Libya, Mexico, Spain, and Palestine? Some of the other states he's mentioning there as well that have joined this matter. These parties may want to do more than just show support for the South African legal team, especially the latter, Palestine, may change the character of the proceedings quite significantly. Can you comment on that, please?
Sure. First, I would say that interventions, and particularly mass interventions, so to say, a relatively new phenomenon in ICJ history. We're talking about an institute that so far, well, until recently was used quite sparingly, and there has been in recent years a spike of interventions that we've seen in the case against Russia brought by Ukraine, but also in the Gambia versus Myanmar case. And I think that in this sense, interventions are to be welcomed, even if procedurally they may complicate matters a bit, especially from the perspective of the court. I say they're to be welcomed because they're not just a showing of support for the applicant state, as Otto is saying. So they do have, I believe, an expressive function, but I think they also have a normative function in the sense that when you see these many states intervening in the proceedings, it kind of reinforces the importance of the obligations at stake. And it's in this sense that I see them as having an important normative value. If we look at the states that have applied or filed the declaration of intervention in this case, there are a number of states that are not directly injured by the commission of genocide by Israel. And then there is Palestine, which is obviously in a legally different position from the other states in that it is directly injured by the violation. But also, if we look at the type of request that Palestine made, it's a little bit different than the other states. All the other states requested to intervene under Article 63 of the statute, that is basically to make submissions on the interpretation of the Genocide Convention. But under this type of intervention, a state, for example, cannot file any evidence before the court in support of South Africa's claim, because their intervention, the scope and the nature of the intervention is limited to the interpretation of the Genocide Convention, whereas Palestine requested to intervene both under Article 63, but also under Article 62. And in this case, the scope of the intervention is potentially much, much broader, including making submissions in support of South Africa's claim. But there is no right to intervene. There has to be a decision from the court authorizing Palestine to intervene. I can also think of potential jurisdictional issues. I would need to double check that, but I'm pretty sure that Israel objected to Palestine's ratification of the Genocide Convention when that happened. So there might be questions as to whether the two states are in a treaty relation or not. But anyway, these are quite technical matters, so I'd rather not go into the details. But yes, it is true that Palestine is in a slightly different position than the other states that have requested to intervene.
Thank you very much, Giulia. Now, Francesca, at least two of our attendees are asking about the responsibility of other states. One asks, if the court says Israel has committed genocide in Gaza, what would this mean for the West? And more specifically, how do you think the USA and the EU will respond? So what are the obligations of these states and communities? Meanwhile, Jindrich Suchi asks, hello, likes to ask about the responsibility and accountability of specifically German politicians, journalists, and institutions in general. So one asks about the states, the other asks about individuals within the states. And is there a way that we as students might use the law against them? If the court says Israel's committed genocide in Gaza, what would this mean for the West? So what is it that states can or should be doing? And what is it that individuals within these states might be doing in response to what the court has ordered?
Yeah, I agree with Giulia that this case in particular, initiated by South Africa, gives the opportunity for the court to elaborate on what obligation to prevent means. It is to be spelled out apparently, because this is clearly something that continues to be violated over and over. It's significant that genocide, while we can argue that all crimes, all international crimes, war crimes, crimes against humanity, and genocide should be averted, prevented, avoided, because there is an obligation in international humanitarian law, in the Geneva Conventions, for all high contracting parties to respect and make respect international humanitarian law, those conventions. At the same time, the Genocide Convention is the soul that creates, that spells out the obligation to prevent. It's true that what does it entail in practice is not spelled out, but there is jurisprudence of the ICJ. I think it's the case of Bosnia versus Serbia, where judges express themselves on the fact that, of course, this obligation kicks in at the moment states take notice, they have knowledge, the times come for these states to have reasonable knowledge of that a genocide might be taking place. And the starting point is therefore, for me, the January 26th, with the recognition by the ICJ of the plausibility of genocide. What does it imply? Well, at least, and together with other special rapporteurs, I've tried to articulate that, looking at the law of state responsibility. There is an obligation not to aid and assist in any possible way a state at the moment it's committing genocide, especially while it's conducting a military operation. So the first obligation for me is not to transfer an arms embargo, declaring an arms embargo. This is something that should have been done by the Security Council, but because of the impasse in the Security Council, because of the paralysis we know of the US veto, this is something that member states are obliged to observe in their own capacity. Eventually, they respond to international justice as states, not as members of the international community. And of course, there is any other measures, in my view, that help the cessation of the wrongful acts, and also work to ensure non-repetitions and reparations as any erga omnes obligation. So this is what comes to my mind as the first set of obligations. And the fact that, well, we know how the UN Security Council is positioned on this issue, but I'm really worried of that the rift between principle and action is much bigger than it appears. Because again, we have now a UN Security Council resolution asking for a ceasefire, which was not vetoed by the United States, and still no one complies with it. Isn't this the path to the end, toward the end of the multilateral system? What are rules for if they can be violated by anyone with impunity?
Thank you very much, Francesca. So we're reaching the end here, and I'm going to ask the three of you for some final comments. You've seen the other questions that have been posed here. Giulia, can we start with you? Can you just provide us with some final words here before we sign off?
Jeff, is there a specific question you'd like me to answer? Maybe the one on compliance?
If you'd like to answer that one, that would be great. Yes, issues around compliance would be wonderful. From Aisha, this is. Yeah,
sure. So the question is about compliance mechanisms and how can we ensure pressure on the court, pressure when the court issues an order, and what is the role for activists and us. As I said before, unfortunately, compliance in the international legal system is left with the parties. Unfortunately, individuals like you and I have no standing whatsoever before the International Court of Justice, which is the subject of this webinar, because only states have standing to appear before the court. But we elect our constituencies. So that's already something important that we can do. But I do feel that there is on the question surrounding Palestine a huge divide between governments and their constituencies. And at the level of civil society, I think there is a lot of support for the cause of the Palestinian people, which is not necessarily taken up by the government. But we've seen activists taking a number of important steps. For example, I recall that a while ago, workers, for example, refused to load arms shipments on a cargo ship that was headed to Israel. And so that's a very concrete step that activists in a specific position have taken. And to try and keep the pressure up, there has been an overwhelming, I think, wave of demonstrations and protests in many states in Europe and beyond in support of the Palestinian cause. And I think that is very important. It's a very important signal for our governments, but it's also very important for the Palestinians themselves. And I'm reluctant to speak for them, but what we've seen online messages that it did matter for them. And especially there have been very many protests led by students, where students really paid the price for their actions. And I think in the words of Palestinian citizens in Gaza, this really mattered to them. So we should keep the pressure up on our governments to keep pressure on Israel.
Thank you very much, Giulia. Really great response. Chris, you're going to answer another question that has been posed here?
Sure, thanks, Jeff. So I think I'll take the first question, which is about historical comparison. And let me say a few things. I think historical comparisons are always difficult, and they always end up flattening out and sometimes obscuring more than they reveal. But to the extent that we're going to make comparisons, I think it's important to remember that Raphael Lemkin himself, the individual who we credit with coining the term genocide, when he sat down to write down his history of genocide, which was unpublished at the time of his death, he began with the Nama and Harare genocide. And he made very clear that throughout the 20th century, there were a number of genocides. And this is important to remember that the experience of genocide is not limited to one unique singular experience, and neither is the law, that the responses of states to genocides that have taken place, including in settler colonial contexts, are state practice. And so when we invoke, and I think this is one function also of the Article 63 interventions, is when states express themselves on what they think genocide means, they are also invoking alternative histories outside of Europe for how genocide has been experienced by the majority of the world's people. And I think we should bear those historical examples in mind, both in thinking of what genocide means and in thinking about how we understand the responses to genocide and our responsibility as a global community, as individuals, for recognizing all the different genocides that have been perpetrated and thinking about this one in its broadest context, not limiting it by way of comparison to one or two.
Thank you very much, Chris. So we've reached the end, unfortunately, but it's been a really rich hour of discussion about the ICJ case brought by South Africa against Israel. I want to give a warm thank you to the panelists, Dr. Chris Gevers, Dr. Giulia Pinzauti, and to the UN Special Rapporteur, Francesca Albanese. Thank you so much for your participation in all of these webinars, helping to organize these. Thanks also to our online participants and to the broader team who organized these seminars, comprising colleagues at the Legal Mobilization Platform and at the ISS, Erasmus University. Specifically, the series has been supported by Sarah Troyan, Marta Heringa, Sarah Njoroge, Jane Pocock, Izzy Del Priore, and Rawan Barakat. Thank you so much. And to you, participants, thank you for watching. Take care.